Hey loves, thank you so much for clicking on my video. So, the last video that I did, I was telling you guys about the importance of having a will. Okay, I have a fan on and I hope it's not making any noise. It's hot, guys. Anyways, the last video I did, I was telling you guys about the importance of having a will. In this video, I'm gonna be telling you guys about intestate succession. That is what happens to your estate if you die and you don't have a will. I hope you guys enjoy the video. Don't forget to subscribe, like the video, comment down below. And if you guys want to know how I achieved this look, I did a tutorial. It's on my Instagram TV, and there it is right there. It's on my Instagram TV. You guys should go and check it out. And I have a bunch of other tutorials on my Instagram TV which you guys might like, might not like, but let me know what you guys think. Let's not waste any time. Let's get into the video. So let me tell you guys what happened to me last week. Last week I recorded this video. It was done and dusted. I even edited it. Did I not delete the video before I could even back it up? And I was so pissed. I was so mad. And I told myself that I am not gonna re-record this video again. But here I am. So let's get right into the video. Let's not waste time, guys. I don't want this video to be long. Okay, so anyways, so if you die and you have a will, we say that you die testate succession. But if you die and you don't have a will, we say that you die intestate succession. For you guys to get context, you guys should go and check out my previous video where I was talking about the importances of having a will. It's quite informative and it will really help you to understand this one. Yeah, well, this one will also be well understood. You guys will get it, but to broaden your knowledge on wills and succession, I'd suggest that you guys go and check out my video before this. Okay, so if you die and you don't have a will, your estate will be dissolved per the Interstate Succession Act 81 of 1987. Okay, I'm gonna write it down here to make sure that you guys got it. So it's the Interstate Succession Act 81 of 1987. This is gonna be quite an informative video. There's gonna be a lot of information, a lot of explaining. So you guys need to stay with me throughout the whole video. And if there's anything you don't get, you guys are welcome to go to any of my social media platforms or even comment on this video and tell me what you don't get so that I can re-explain it maybe in a different way. Just whatever we can do to make sure that you guys get it. So there is a set order of preference. Remember, if you have a will, your estate will be dissolved per the regulations that you have set out in your will. You guys need to have a will, guys. I can't stress the importance of having a will enough, but that's not what I'm here for today. The importance of having a will is stressed enough in the previous video. So here, we're not stressing that. Here, I'm just telling you guys what happens if you die and you don't have a will. So there's a set order of preference of who gets what, who comes first, and how the thing gets dissolved. So the first person who's gonna be looked into if you die and you don't have a will is your spouse. Remember, I said there's a set list of preference. So the first person is your spouse. So if you die and you don't have a will and you have a spouse, your spouse is gonna get all your estate. Your spouse is gonna get everything. But this is the case only if you don't have kids. So if you don't have kids and you only have a spouse, your spouse will basically get your entire estate. Number 2, your kids. So remember, I said if you have a spouse and you don't have kids, then your spouse gets everything. Now, if you don't have a spouse but you have kids, then your kids will get all your estate. Your estate will be divided equally amongst your kids. I'm going to be making examples later on with situations where you have both the spouse and the children. For now, I'm just focusing on if there's only that one particular person, right? Stay with me. Number 3, your parents. So if you don't have a spouse and you don't have children, the next person that is going to be looked at to inherit your estate is going to be your parents. So if there's no kids, no spouse, then your parents are going to get equal shares of your estate. But if you don't have parents and you don't have a spouse and you don't have kids, number 4, the person they're going to look at is your siblings. So whatever number of siblings you have, your estate will be divided equally amongst them. And number 5, the last person that the Master of the High Court will look at is your next blood relative, right? Okay, so can we put this information aside? Let me give you guys this extra information. So when a person dies, right, whoever is left, be it spouse, children, parents, or whatever, they need to go to the Master of the High Court, right? And at the Master of the High Court, they will choose an executor. Remember, if you have a will, I'm gonna keep saying remember because I'm gonna assume that you guys watched the previous video. So remember, the Master of the High Court will choose an executor. If you have a will, you choose your own executor. You make all the decisions. But if you don't have a will, then the Master of the High Court is going to make those decisions for you. So the Master of the High Court is going to choose an executor. And after choosing an executor, the executor will follow these steps in giving out, or rather dissolving, your estate. So this is how the executor is going to dissolve your estate. These are the things they're going to be looking into. Okay, so your estate is not gonna just be dissolved by your family. There's gonna be a person that is gonna be set by the Master of the High Court who's gonna do these things, who's gonna carry out these tasks. Okay, so I'm gonna introduce you guys to a concept. So I need you guys to stay with me. I'm going to introduce you guys to a concept. The concept is child's share. Okay? Child's share. That's the concept. Basically, how it works is that the child's share is a fixed amount. Ane? Stay with me. It is a fixed amount. This is for when you have, like, the child's share only applies for when you have children and spouse and that person, right? So if it's only just the children that are left, then you don't need to worry yourself about child's share. But if you have a spouse and you have children, then the concept of child's share comes into play. Remember, spouse is not girlfriends and boyfriends, okay? So, child's share is a fixed amount of 125,000 rands. Ane, stay with me. So, how the Succession Act, the Interstate Succession Act has set it out is that there's a formula, right? Stay with me. There's a formula. And the formula goes net worth, that is your entire estate, right, divided by the number of kids plus your spouse. So there is the formula. It is your total estate, what your estate is worth, divided by your spouse plus the number of kids you have. I'm gonna put the formula there, and there's gonna be a lot of math work, guys, because I want you guys to get this. Okay, so child's share. This is where the child's share comes into play. So before making examples, I want to explain how the child's share comes into play with all of this, and then I'm going to make the examples so that you guys get it, just to add precision. So there's your estate, and then there's your spouse, and then there's the number of kids that you guys have, right? So how this works is your estate is wound up, and we find what your estate is worth, right? So it's that number divided by the number of kids you have plus your spouse. So if you have 2 kids and a spouse, it's going to be divided by 3, right? Whatever that is equal to, like whatever results you get from that, that is what we're going to use for the child's share. So I told you guys that the child's share is a fixed amount of 125,000 rands, right? So after doing that equation, after putting the relevant numbers in that equation, and you find your answer, that number, if it is less than the child's share, remember the child's share is 125,000 rands. If it's less than that, then the spouse gets the 125,000 rands, and whatever is remaining from your estate will be divided amongst your kids. But if it is greater than the 125,000 rands, then both your spouse and your kids will get an equal amount. Basically, what I'm saying is your spouse is entitled to what is greater between the child's share and what's left of your estate after dividing. So between the two, whichever is greater, that is what your spouse is gonna get, right? And if what is greater is the 125,000, the child's share, then it's gonna be subtracted from your estate, and whatever is remaining is gonna be divided equally amongst your kids. I hope you guys get this. Okay, so we're gonna move on to examples, right? Remember, we're still focusing on if you have kids and a spouse, right? So what I want to explain to you next is what happens when the person, the diseased estate is less than the 125,000 rands. So my example, so a man dies and he leaves behind 3 kids and his wife. His estate winds up to 120,000. What happens to his estate? Guys, the spouse gets everything. It's less than the 125,000. She's not gonna share the estate with the kids. She's entitled to the entire estate, you guys, because it is less than the 125,000 rands. So I'm gonna move on to my next example. So in this example, it's an example where the estate, like after calculating, the estate is less than the child's share, right? So a woman dies and she leaves behind 2 kids and her husband. Her estate winds up to 250,000 rands, right? So we're gonna put that in the formula, right? It's gonna be 250,000 divided by 3. Remember, it's 2 kids plus the spouse, which equals to 3. And the final answer is gonna be 83,333. So this is the final amount, which is 83,333, and this is the child's share of 125,000 rands. Which one is greater? The child's share. So therefore, the spouse gets 125,000 rands. And then whatever is remaining from the estate will be divided equally amongst the 2 kids. Allow me to add this, guys. Adopted kids are taken as your biological kids, right? So they will also inherit just as your kids would have inherited, right? And also, if there were any kids that you were taking care of prior to your death, kids that you regarded as your own, they will also inherit as your kids would have inherited, right? So let's move on to my next example. A woman dies. She leaves behind 2 kids and a spouse, right? And a spouse. And then her estate winds up to 5 million rands, right? So we're going to put it in the formula. It's going to be 5,000 rands divided by 3. And that is going to equal 1.6 million rands. So because the 1.6 million rands is greater than the child's share, then your spouse will get the 1.6 million rands, and so will your kids. Just to add precision on this, if your estate is like after doing the calculations and what is left is greater than the child's share, then your spouse and your kids will get an equal share. Now I'm gonna move on to an example where you don't have a spouse, you don't have kids, and you just have your parents and your siblings. So if you have parents and you have siblings, remember, if you don't have a spouse and you have children, parents and siblings, your parents and siblings are not going to get anything. They are only considered if you don't have children, right? If you have children, then your children are going to get your estate. So your parents get equal shares. Remember, I told you that your estate will be divided equally amongst your beneficiaries. So if you have both your parents, they are both going to get 50% each of whatever is left of your estate. But if you have one parent left and you have siblings, your one parent who's left is going to get 50%. The 50% that they would have gotten had your other parent been alive, they're going to get that 50%. And then the other 50% that would have gone to your other parent who's predeceased will be split equally amongst your siblings. So if you have maybe 2 siblings and you have maybe your dad, then your dad is going to get 50% of your estate, and the other 50% will be split equally amongst your 2 siblings. But this is for only people who don't have a spouse or children. But if you do have a spouse or children, then your siblings and your parents are not going to be considered when it comes to inheriting your estate. They will not be considered at all, you guys, that is why it is important for you guys to leave behind a will, so that you guys can have the final say. Like, your will grants you your final say. So that is it, you guys. Thank you so much for watching the video. Tell me what you guys think. Tell me if you guys want me to talk about anything else in my next video, because I've covered succession. So tell me what you guys would like me to talk about in my next video. And again, this look is on my Instagram TV. You guys should check it out. I'm gonna put it up there again. There we go. So you guys should check it out. You guys don't forget to subscribe. Let's grow our channel. It's not my channel, guys, it's our channel. So let's grow our channel, you guys. Also, thank you so much for clicking on the video, man. Thank you so much for your support, you guys. It would also be great if you guys followed me on my social media platforms. I'm gonna put them up there. I'm gonna also put them in the description box. You guys engage me, engage me on all of these things I talk about. I'm getting a few engagements, but it's quite less. So if you guys could engage me on certain things, ask questions, let's make it a conversation, you guys. Thank you so much.